Good morning to you. It's a great day here at Elville & Associates, and we're thankful to have you here for another edition of our Elville webinar series. Today's topic is the financial aspects of estate planning, presented by Elville & Associates Senior Associate Attorney and Estate Planning Team Leader, Shannon Werbeck. My name is Jeff Stauffer, Community Relations Director with Elville & Associates, and I'll be your moderator for today's presentation. As always, welcome to those that are new to our educational webinar series and also to those that are frequent attendees. We encourage your general questions today, so please note them in the questions panel on your screen, and we will pause periodically throughout the presentation to address them. Your questions add a lot of value to the presentation. They help others learn, so don't be shy in posing your questions at any time. You also received the presentation slides by email from me yesterday. To take notes on them if you wish, these materials are also available in the section marked handouts on your panel to download at this time on your screen. We also have some professionals on today's presentation, so thanks for being here and your support of our webinar series. You may receive 1.5 continuing education hours for attending. So please send me your ID number if I don't have it already, if you'd like me to submit your CE hours for approval, or if you'd like to receive a certificate of attendance for attending. I'll be submitting the CE hours tomorrow morning for approval. Everyone will also receive a post-webinar feedback email right after the presentation, so please take just a minute or two to fill out this very brief survey to offer feedback about today's presentation. And here at Elville & Associates, we always want to be a resource to you for your families and your planning needs. So if you need to get started with your planning, if you have old documents that need to be addressed, consider a consultation with Shannon after today's presentation. Use today's education as a jumping off point to get your planning started. Consultations are always the most ideal way to have your specific questions answered, have Shannon understand your situation, and help create solutions and a path forward for you. So as always, I'd like to offer Shannon and the firm a brief but proper introduction before we get started, and we'll jump right in. So you should be able to see my screen here. Elville & Associates, we were founded in 2010 by our managing principal and lead attorney, Stephen Elville. We have several different practice areas here at the firm that we focus on, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, tax planning and asset protection. We have 9 attorneys, 12 staff members in 5 locations. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, client education, and superior legal technical knowledge. We do focus on education a lot here at Elville & Associates in several ways, through our planning processes with our clients, through educational webinars and workshops in the communities that we serve each year, and also by way of our accredited client care program. We're one of only 2 firms in Maryland to have an accredited client care program, or CCP as we call it, accredited by the Client Care Program in Boston. We also focus on the ideals of client education, collaboration, and compassion in mind every day here at Elville & Associates. Just a bit about Shannon. Her work as an attorney for the past several years has been centered in estate planning, along with assisting clients with special needs planning and elder law related matters. She graduated from the University of Baltimore School of Law, was admitted to the Maryland Bar in 2020, and is a member of the Maryland State Bar Association. Shannon educates and counsels clients through the entire estate planning process, beginning with the initial consultation, followed by the design and implementation of their plans, as well as the necessary maintenance and updating of their planning as changes occur in their lives and laws over time. And Shannon is very true and works hard to focus on the ideals that we work on here every day of client education, collaboration, and compassion, and is very, very focused on those every day. Shannon was also nominated by her peers and named to the Rising Stars list of Maryland Super Lawyers for the first time in 2023. So congratulations to Shannon. And I think that's going to be the first of many, many nominations to that list, if I dare say. So we're going to go ahead and get started here. I have a brief poll that I'd like to offer to see what's brought you here today for our presentation. And I'll stop sharing my screen here. And our poll for today is, what is your primary interest in today's webinar? And the choices are, as I launch the poll, 1, I have no planning and felt this would be a good start. 2, I have a plan, but my financial picture is not defined in it. 3, I'm an advisor here to learn to better serve my clients. And 4, I have outdated documents that need to be reviewed. So make the choice that best suits your situation. We appreciate you being here on this warm, late October day. And let's see what our choices are here. Our selections. Give it another few seconds. Hope everybody's having a great week. It's busy here as it always is. Blessed to be busy. All right. We have about 80% of the attendees having made their choice. 11% say, I have no planning in place and felt this would be a good start. 44% say, I have a plan, but my financial picture is not defined in it. 28% say, I'm an advisor here to learn to better serve my clients. And last but not least, 17% say, I have outdated documents that need to be reviewed. So a somewhat varied group, Shannon.
Good.
And I'm going to go ahead and make you the presenter.
Okay.
So you see that button pop up on your screen. I'm going to close this poll first of all. There we go. Maybe I need to make you the, okay, there we go. Do you see that button?
I do, yes.
Okay, great.
Okay, so I'm going to pull up my screen. And Jeff, are you able to see the slides?
I am. I see the
Is it the
next slide. It says that next slide over on the right.
Okay, give me 1 second.
Go to those display settings. Maybe that'll change that around a little bit.
Okay. All right.
There we go. Yep, looks good.
Okay, give me 1 second because, okay, you're able to see it now?
I am. Yep, looks good.
Perfect. Awesome. I have 2 screens, everybody, so kind of navigating which screen is where sometimes it becomes a complication, but we figured it out. Thank you, Jeff, for your introduction today. Good morning, everyone. My name is Shannon Werbeck. Like Jeff said, I'm an estate planning attorney at Elville and Associates. Thank you for joining me here today to, while I talk about the topic of financial planning aspects of estate planning. So how financial planning and estate planning really overlap, and also how they're distinct and they really need each other to really make sure that your goals are met, especially on the estate planning side. So first, I want to talk about give me 1 second, Jeff, my screen kind of got weird. Okay, so first I want to talk about what is financial planning, okay? And I want to also mention that I am not a financial planner, okay? We often refer clients to certain financial planners and financial advisors who could, go into much greater detail about what financial planning actually is and what that entails. But a simplistic way of thinking about it is, financial planning first is a comprehensive analysis of your goals, your tolerance to risk, your life stage, so where you're at in your life, and your family, health, and personal circumstances that are relevant to you. And then thinking through what suitable investments may be available, including insurance and general savings, and then taking into account budgeting and tax planning, all to make sure that you achieve your financial goals. So simply put, making sure you have enough money to accomplish, your lifetime and after death goals. So then what is estate planning? And it's very remarkable how these look pretty similar, especially the first part of this, because estate planning also starts with a comprehensive analysis of what your goals are, your risk for tolerance, what stage you're at in your life, your family health and personal circumstances that are relevant to you, plus taking into account that your financial picture and your asset picture, and then thinking about the suitable legal documents that will really achieve your goals. So I do want to do a brief overview on estate planning because many times I have clients who come in and maybe do an initial consultation, and they believe that estate planning is only relevant at death. So people come in and they say, I want to talk about what happens with my stuff when I pass away. I want to make sure it goes to the correct person, or I want to make sure that my minor child is taken care of in the event I pass away. I need to name a guardian of my child. And while those things are very important, and of course, very important to plan for, what's equally as important is planning for what happens during your lifetime if, God forbid, you were to become incapacitated. Who's going to make financial decisions on your behalf? Who's going to make healthcare decisions on your behalf? So estate planning covers planning for the care of your health and property and assets while you're alive, particularly in the event that you become incapacitated, and also planning for the disposition of your property at death and for the protection and care of those who are dependent upon you. So again, simply put, having the necessary legal documents to dictate who will handle things for you if you are unable to, either due to incapacity or death, and how they will handle things. So actually within those documents, you laying out how you want your assets to be handled during that time, or your healthcare decisions to be handled during that time. So how do financial planning and estate planning overlap? Okay, so I'm going to talk about that in the next slide. So a good starting point, and as you saw in both the outline for what is estate planning, what is financial planning, a common denominator that we start with is what are your goals, okay? And so next to think about is how will you finance your goals? And that's really where a financial advisor comes into play, who will be able to help you think through and plan through how to accomplish your goals. And then how will you ensure that your goals will be respected and accomplished in the event you're unable to do so for yourself, okay? So I have a few examples here of just some goals that I've seen frequent goals that I've seen from clients, and how financial planning plays a role in that, as well as estate planning. So one example I have is I've had people state to me, I have this residential property, or I have, a family cabin or a beach house, and I want to make sure that after my death, that remains in the family. So let's think about the financial planning aspect of that. How do you intend for the cost and maintenance associated with those expenses to keep the property in your family to be handled? How do you plan for your family members who will inherit this property from you, to keep up with the costs associated with keeping the property in the family? So that's something you could work on a financial advisor with. And then from an estate planning point of view, that perspective is thinking through the legal documents and the structure of the documents that we need to have in place to ensure that that goal is accomplished. And in that specific instance, what may be a good idea is to have a trust in place. And that's often the answer in that type of situation. One other example I'm going to give is sometimes we have clients who, come in and they have children or grandchildren who have special needs, okay? And their goal is really, they want to make sure that that child or that grandchild with special needs is provided for at their death, okay? So, the financial planning aspect of that is, how much is your child or grandchild likely to need, and how are you going to plan to have enough assets to fund, that need when they're gone? And then the important thing from an estate planning perspective is that we absolutely do not want to leave assets outright to a child or a grandchild with special needs, or somebody who is applying for or receiving needs-based governmental benefits or may do so in the future, okay? Because that would disrupt their governmental benefits. So there's planning structures that we can create so that the money that you leave that child or that grandchild with special needs doesn't disrupt their governmental benefits, but it actually supplements them. So now I want to go into what is asset alignment. And the reason why I want to start talking about this is because the next slide is going to go into what is a successful estate plan. And we're going to, and step 2 talks about asset alignment. So just in general, asset alignment is ensuring that the lifetime and after death access to and distribution of your assets are aligned with your estate, with your intentions and your goals. So making sure that whatever your intentions are in terms of your assets, both while you're alive and after your death, are in line with your goals. So what is a successful estate plan? And a successful estate planning is different for everybody. And that's why it's great to come, have an initial consultation and discuss with an attorney which legal documents are appropriate for you and your circumstances. So step 1 is, again, what are the appropriate legal documents? So we want to make sure that you at least have certain types of documents in place. A power of attorney document, and specifically what I'm talking about is a financial power of attorney document. What happens in the event you become incapacitated? Who's going to handle your finances? Who's going to continue paying your bills? Maybe pay your mortgage, pay your taxes, keep up with your property? Who's going to step in your shoes and act as you so things keep going? So you want to make sure that you have a financial power of attorney in place to name somebody who can do those types of things for you. Next is an advanced medical directive. So these 2 documents, power of attorney and advanced medical directive, are what I call incapacity planning documents because they're during life documents, so in the event you become incapacitated. So an advanced medical directive is, what if you were to become incapacitated? Who's going to make healthcare decisions on your behalf? So naming people to make those healthcare decisions, and then an advanced medical directive goes into more of your intentions about what you'd want to happen during your end-of-life care, or your post-death instructions for organ donation or funeral and burial. So those documents are very important because what they do is they avoid guardianship. They avoid the court having to become involved and name a guardian of your person or property. So it's a least restrictive mean to guardianship. And then next, there's, having a will or a trust. And, each document, whether it's a will or a trust, whatever plan you choose to go with, that really depends on coming in, meeting with the attorney, and determining, is a will-based plan best for you to go? What are your goals? What is your motivation? Do you want to avoid probate? Then maybe we need to talk about a trust-based plan. Or do you have a child maybe who has special needs? Maybe we need to do a trust-based plan to make sure that we don't disrupt those governmental benefits. And then step 2 is taking into account and making sure your assets are aligned with your plan. So making sure that ownership or titling on your assets and your beneficiary designations are in alignment with your estate plan and your legal documents. So another thing I commonly hear from people is, I have a will or I have a trust in place, so I don't need to do asset alignment. My will or my trust will just take care of that. And that's not actually true, and we'll kind of talk more about that in other slides, but it is a perfect example of why having a significant overlap between estate planning and financial planning is vital to ensure that your estate planning documents and your goals work in the long run in the future. So having an estate planning attorney and a financial advisor work together is very vital. Real quickly on this slide again, I just want to point out, and I know I pointed it out in the beginning, but there is no one right plan for everyone. Not every plan is right for every single person, but a successful plan is one where we have taken into account your goals, your intentions, and preparing the correct legal structure of documents, and then aligning your assets to those documents so that they flow correctly to meet your goals. So I just wanted to point on that one more time. So let's talk about the nuances of beneficiary designations and payable upon death designations and transferable upon death designations. Now, it's not recommended that all of your assets be beneficiary designated and payable upon death designated and transferable upon death designated. But there are some types of assets, depending on your estate plan and who that specific beneficiary is, where, you know, having a beneficiary designation or a payable upon death designation is a good idea. So I'm going to give a few examples of this. So one example is retirement plan accounts. So it's vital that the beneficiary designation on those accounts be complete and kept up to date, because those types of accounts are very nuanced from a tax perspective. So we want to have very, careful, and clear instructions in terms of making those beneficiary designations correctly done. So, for example, trust planning. For a retirement plan account, we don't want to change the ownership of the retirement plan account to the trust to avoid probate, because changing that ownership would actually make it so that account is treated as it being liquidated, and you'd be taxed on it right away. So that's a tax nuance. So we found that just by properly beneficiary designating that account and making sure it's in line with your estate plan and what your estate plan says, accomplishes that goal. Another example is checking accounts. So we advise clients to make checking accounts payable upon death in certain situations, and that's typically because there's, a client's utilizing a trust-based plan for their estate plan, and we don't want to cause headaches for clients during their lifetime that can come with, checking accounts and aligning it to the trust. So, typically clients, they just have their income set up so that it funnels into that account, into their checking account, and then that income is automatically taken out, used to pay their debts and their bills. So typically that means that checking account, it never gets high enough that it's, really an issue, because there's so many ins and outs of that account on a monthly basis. So in that instance, payable upon death to the trust is, the best approach. Jeff, do we have any questions?
Actually, it looks like we just had one pop up about 5 seconds ago. Let me take a look at it. So it looks like the first question here is pros and cons of designating a trust as a beneficiary of a retirement account.
Okay, so I'm going to kind of get into that a little bit. And when you say trust, it really depends what you mean by that. So there are certain times where we think that a trust should be, or a retirement plan account should be beneficiary designated to a trust, and I'm going to go into that further in other slides, but those are instances where maybe you have a minor child, or you're setting up some type of supplemental needs trust for a child, or what we call a legacy trust, which I'll go into in another slide. But there are certain circumstances where that's actually a good idea. Now, some people, there are some people who, with the beneficiary designation, you can make it to your, say, revocable trust, but we don't recommend that. We actually recommend it go directly to the person you want it to go to, whether that be their supplemental needs trust, their legacy trust, you know, so, and I'm going to talk about it more in the other slides, but, you know, it also really just depends on your situation. And so, you know, by coming in and talking to us, and by us having an overview of what your financials are, and, you know, what your family needs are and your health needs are, we can better talk about those pros and cons, and what types of trusts should be designated as a beneficiary designation on retirement plan accounts. But I'm going to talk about that, I believe, a little bit more on another slide. But, you know, what I will say is I highly recommend coming in and talking about your goals, and we can further talk about whether that's a good idea and the pros and cons for your specific situation of having a trust listed as payable or as a beneficiary designation on retirement plan accounts.
Okay, Shannon, thanks very much.
Any other questions, Jeff?
Not at this time, thank you.
Okay, of course. Okay, so next, I want to talk about understanding non-probate transfer devices. So sometimes people utilize these non-probate transfer devices in place of their estate plan. So they're really skipping, you know, a vital step. And so these types of non-probate transfer devices are naming somebody jointly on an account, naming somebody as a beneficiary designation, doing a life estate deed, naming somebody as transferable upon death or payable upon death on an account, and in trust for accounts. So like I said in the previous slide, there are some instances where it is a good idea to do payable upon death, or it is a good idea to have a beneficiary designation on certain types of accounts, but that shouldn't be your complete estate plan. So I want to give a few examples to explain this further. So I've had clients come in and say, you know, well, I made my daughter or my children or whoever, you know, my granddaughter, a joint owner on all of my assets. And by doing so, that's made things simple. I don't need an estate plan. She can access my money during my lifetime. If I'm unable to, you know, manage my assets, she can, you know, pay my bills for me and do all those types of things for me. And then when I die, you know, all that money just goes to her. There's no need for probate. So I want to talk about the risk in doing that. So the risk of doing that is that you are now risking that that account is now open to your daughter's creditors. So unfortunately, we can't foresee the future. We don't know what's, you know, going to happen. And, you know, what if your daughter was going through a divorce? Or what if she got into a car accident? So that account opens, although she's just jointly on the account, and technically that's, you believe it to be your money, from a creditor's perspective, that's part of her assets as well. And so just something to think about in regard to that. So we want to have an estate plan in place. And if the goal is really to avoid probate, and that's why you're naming, you know, your daughter on your assets, you know, I would then recommend doing a revocable living trust plan. Another example is, you know, I've had somebody say, all of my assets are payable upon death, or transferable upon death, or beneficiary designated. And, you know, now I don't need an estate plan. So to that I say, what happens if at your death, the person you have named has predeceased you and you haven't updated that beneficiary designation? So now that asset will have to go through probate. And if you did not have an estate plan in place, then your probate estate, you know, may not go where you want it to go to. Okay, so if you had an appropriate estate plan in place, you know, when that asset has to go through probate, at least it designates where that would go to. Another example I want to talk about is the risk of naming somebody as payable upon death on your accounts. So what happens if that person is going through some type of creditor situation? And again, we cannot predict the future. We cannot predict if somebody is going to be in some type of creditor situation in the future. And we may think that things are all well, but again, what if they get into a car accident and they're sued, or they get divorced? And now that money is going to instantly go to them upon your death. And because they're in a creditor situation, now it instantly goes from them to their creditors. So, not having an estate plan in place and not having your assets aligned with your estate plan, it doesn't talk about all the different types of contingencies. And, if something, happened, just as I described, your estate plan would be able to say, okay, this happened, so now we need to do this instead. And you can dictate what that is. So you want to have a robust estate plan that takes into account different contingencies if certain things occur and what you'd want to happen in those situations.
Shannon, can we pause for a brief question related
Yes.
to what you just talked about?
Yes, of course.
And question is, my husband and I have a joint checking account and each has a revocable trust with spouse as trustee. Did you say that the checking account should go into the trust of the deceased by POD?
So there's many ways of doing that. What we actually recommend through our asset alignment process is that your checking account be payable upon death to the trust. Now, I will say that there's some people who just say, at that point, there's probably not going to be much money within the account, so we just make it payable upon not a significant amount of money because of the, ins and outs of that account, income coming in, and then that being used to pay debts. So, it is perfectly fine, to name a specific person who that goes to, as long as it, is in line with your estate plan. So, no, the answer isn't always that it goes to a trust. That's just what we recommend. But it's also perfectly fine to have a specific person listed as payable upon death on the checking account. And I welcome you to come in and have us look over your estate planning documents. Maybe we did them specifically, and we can discuss that further and discuss your needs and your goals and discuss, how that payable upon death designation will most meet your goals and your intentions. Jeff, are there any other questions?
Not right now, thank you.
Okay, perfect. Thank you. Okay, so we were talking about the non-probate devices and how some people use those instead of an estate plan. And I also want to talk about, remember a few slides ago, I was talking about how some people say, well, I have a will or I have a revocable living trust in place, so I don't need to do the asset alignment portion of that. So with a revocable living trust, you want to align all of your assets to your trust during your lifetime. And there's specific, of course, nuances to that, but most of them do get aligned to your trust during your lifetime to avoid probate. So simply just preparing a revocable living trust and executing it, that doesn't mean that you're all done. That means you need to do asset alignment as well. And even with will-based planning, we want to talk about asset alignment. So there's some people who come in here and maybe they do, say, will-based planning, and we still need to look at your assets. We need to look at how your assets are listed. Is somebody a joint owner on one of your accounts? Is somebody listed as payable upon death, or do you have a life estate deed? And we want to talk about, is that in line with what your actual estate plan is? And if you utilize payable upon death designations, if in your last will and testament, say, for example, you're stating, I want this specific asset to go to a specific person, and then over here, the account is listed as payable upon death, legally, the payable upon death designation is what's actually going to go through upon your death. So we want to make sure that everything lines up, and that most things kind of go through a will or trust to hit on all of those different contingencies and things and risks of things that could happen. So we can talk about, what happens in those situations, what's next. But I just want to briefly show, if something is is jointly owned, it passes to the surviving joint owner. If something is listed as payable upon death, it passes to the beneficiary, transferable upon death, beneficiary designated, and trusts for accounts all pass to beneficiaries. And then life estate deeds pass to remainder men. Okay. So another thing I want to bring up is something I hear from clients from time to time. They come in, maybe they're doing an initial consultation, or we're just talking about the asset planning portion of their estate planning, and they say, isn't it true that I shouldn't be leaving my 401k or my IRA to my minor child or grandchild? And I go through an analysis with them. I talk about the complications of having a minor child inherit assets. I talk about the risk of designating somebody else instead, and the value of a robust estate plan. So let's talk about the complications of a minor inheriting assets. So the complications are, if somebody is under the age of 18, they can't legally own property. So in Maryland, the age of majority is 18. So what if somebody who is, say, 16 years old or even younger inherits from you, in terms of maybe you have a minor listed on a 401k or an IRA as a beneficiary designation? What happens next is that the court will need to become involved. A matter will need to be opened where the court appoints a guardian to be responsible for that inherited asset on behalf of the minor until the minor turns 18. So there's multiple negatives to that. So number one, we want to avoid the court's involvement as much as possible. And I think everybody can agree, if we can keep things out of court, that's the best possible approach. And then the second thing I want to talk about is, even at 18, most people can agree, and it really depends on your situation, but most people can agree that an 18-year-old, having an 18-year-old be in charge of a large sum of money isn't always a great idea. I know at 18, I was in college, and I would like to think that, me and my sisters and whoever at 18 would be able to handle that type of thing, and use it for books and things that it's important for. But, if at 18, there's always, we're not at that stage in our life where we can handle that type of and manage that type of large sum of money. So it will require the court's involvement unless appropriate planning is done ahead of time. Okay, so the next part where I talk about the risks of designating assets to somebody else instead. So what I mean by this is, sometimes I have a client come in who says, well, to avoid all this complication, I'm just going to name somebody else instead. And they know where I want that money to go to. They know what I want that money in the 401k to be used for. I want it to be used for my minor child, and they'll take care of that. They'll use it for their benefit, and they'll have my intentions in mind. And while that sounds great, we cannot foresee the future. We don't know, although you believe that that person will use those assets in that general way, we just don't have a guarantee, okay? Another thing to think about is, what happens if that person who you have named as a beneficiary designation, what happens if they lose their mental capacity? So you've passed away, you have them as a beneficiary designation on your 401k because you think that that's the best way for there to be less complications, because they'll use that money for the benefit of your minor child. So if they become incapacitated, then that means that somebody else is in charge of their assets. So their power of attorney, whether it be a power of attorney or guardian of their property. And who's to say that that person is going to use, that for the minor child? Because, that asset is now in, the incapacitated person's name. So the person who is their power of attorney may think, well, I'm not going to use it for these children or these minor children. I think it needs to be used for, the health and the care of the person who I am power of attorney over, who is incapacitated. So there's just no guarantee that that money will be used for your minor child if you designate somebody else, because we just cannot predict the future. So what is the solution? So the solution is to make sure that you've built in your estate plan for your minor child or your grandchild that this type of money be left in trust for their benefit. So you'll be leaving it in trust for their benefit, and you get to dictate who the trustee is, which means the person who will manage those assets in trust for your minor child. So you also get to designate, how that money will be used and what your intentions are for that money. You can also designate, maybe you will have a trustee of that account while your child is a minor, or even, after they're a minor, but maybe you believe at 25 they can at least be a co-trustee and help learn the ropes to manage that large sum of money. And then maybe at age, say 30, they can manage the assets themselves. You can say specifically what your goals are for that money and how it is to be used and how it's to be distributed at different times throughout that child's life. So that, in connection with having a minor child or grandchild as listed as a beneficiary designation on a 401k or an IRA, the best thing to do would to have a trust be the designation, and that would accomplish the goal of avoiding the court having to become involved and avoid somebody who is very young as 18 getting a large sum of money and having to manage that money and hoping that they'll use it maturely in what it should be used for. Okay, so I want to talk a little bit about the financial advisor, and from an estate planning perspective, our thoughts on having a financial advisor. So in my opinion, it is vital that you have a financial advisor. I mean, the benefit is that you're developing a personal relationship with your financial advisor. They are, they know all of your assets and all of your circumstances. They know your family situation, and they have an objective oversight. And they, God forbid you were to become incapacitated or you passed away, then they can assist a fiduciary in acting on your behalf because all of that information is in one place. And that gives families and beneficiaries great comfort knowing that there's a person to go to who can help them and where all the information is just located in one place, so there's a seamless transition. And they can just bring great insight to ensure the success of an estate plan. So, working with an estate planning attorney and making sure that on a financial, the financial aspect and estate planning aspect, that both of those are driving towards the same goal and intentions. And so that's why it's ideal to have an advisory team. So to have an estate planning attorney, a financial advisor, and a tax advisor. And this is a way to make sure, of course, we can't foresee the future, and there's work for you to be done as well in terms of updating your estate plan and keeping everybody up to date with what your finances are and properties that you come into. But, this is your best chance, having this type of advisory team, in meeting your goals and making sure that your intentions are met. Okay, so next steps, what do we suggest you do now? So a path forward is that you set an initial consultation with Elville and Associates. So we actually offer complimentary consultations, 1-hour consultations. We would ask you to complete an estate planning questionnaire, and in that questionnaire would talk about or ask you information about yourself, your family situation, if somebody has special needs, if there's need for elder law planning, if anybody's on certain governmental benefits. It talks about what your assets are, and it gives a great overview of of what will need to be discussed in your initial consultation. You should relax and understand that there is nothing to fear. Estate planning attorneys are here to help, and we can always recommend you to great financial advisors who we work with on a daily basis to help and make sure that your goals are met upon your death and even during your incapacity. And it's a great idea to, even if you currently have estate planning documents, to bring them in to do a complete review with us. Maybe there's been changes in Maryland law that are not reflected in your documents that need to be reflected. People are in and out of your life. Your assets are forever changing. Maryland law is forever changing. So it's a great idea to bring estate planning documents in for a complete review to talk about if your documents are still accomplishing your goals and are still relevant to your current circumstances. And then consider whether you have an advisory team, which includes a financial advisor and a CPA. And if you don't, we can absolutely, recommend you to certain people, depending on your situation. We have a great list of financial advisors and CPAs who are wonderful and who we frequently work with. And then prepare any questions or concerns you may have for discussion. So come in with a list of questions, come in with any concerns, come in with what your goals are, so we can really talk to you and structure a plan on the estate planning side and financial side that meets your intentions. Take the time to think and to decide what's important to you and what your goals are. So thank you everyone for joining us here today. And Jeff, at this time, are there any other questions?
Well, thanks very much, Shannon. We do have some more questions here, which I'll run by you here. And now would be your time, as always, to get those final questions into Shannon. And we'll go through them, and I'll have a couple of closing comments, and then we'll go ahead and wrap up. So let's go through the few questions that we have here. First one is, let me get to the right one, sorry. For married couples, to create a trust, do you create a, quote, family trust, or does each individual have their own? And how does this work with asset alignment?
Okay, so that's a great question. And it really depends on your current situation. So we have married couples come in, and maybe their assets are all, jointly owned. Maybe all of their accounts, both their checking accounts, their savings accounts, all of their accounts, they're both spouses are listed on that account. And maybe they have a house and their deed is listed as tenants by entirety. So if everything is jointly owned, then doing a joint revocable living trust plan would be in your best interest. And then, some people come in and they do their finances differently. They don't own things jointly. And to that I say, you can do separate revocable trusts, but you can also still do a joint trust. And there's a schedule on the bottom of the trust where you can specifically list that these are the types of assets that are just in my name. And these are the types of assets that are, maybe in my husband or wife's name. And I want those to specifically go to certain people and just be treated as part of my estate. So even if we do joint planning, we can still designate that certain things are considered to be yours, or certain accounts are considered just part of your estate. And the asset alignment approach to that is you would work with our asset alignment coordinator who would help you with that process. And of course, we would work with a financial advisor as well to make sure that your accounts are designated correctly. But the asset alignment portion to that is, if it's a joint trust, everything would be aligned to the joint trust. If it's separate trusts, everything in the separate spouses' names would go to their trust and would be designated specifically by their trust.
Okay, very good. Thank you. Next question is from one of our good clients here, Mr. Smith. I'm not giving anything away by saying Mr. Smith because there's a lot of Mr. Smiths.
Yes, there are.
If a trust is a beneficiary of a retirement plan, though, does that make it taxable all at once versus if not? Just a bit confused, but perhaps I need more coffee, he says.
That's a great question. So having a trust, so I'm assuming you're referring maybe to a revocable living trust, having that listed as a beneficiary designation on a retirement plan account, no, that doesn't mean it's taxed all at once. What I was specifically talking about is when we do asset alignment, we change the ownership of your accounts to the name of your trust, to you as the trustee of the trust. But in regard to retirement plan accounts, we don't want to actually change that ownership, because when we do, that's when it's treated as the account being liquidated and you'd be taxed on it all at once. So no, having your revocable trust listed as a beneficiary designation on your retirement plan account does not mean that you would be taxed on it all at once.
Okay, and looks like we have a couple more here. Do we have a tax advisor list to recommend to clients or potential clients?
So, so we do have a list, and that's some information. Maybe you can reach out to Jeff for, and I can provide to Jeff, and he can send that over your way. But yes, absolutely, we can recommend tax advisor CPAs to you.
Sure. Yeah, if you're anybody on the call, whether you're a client or a non-client, are in need of a good financial advisor, CPA, life insurance professional, life care manager, anything, we're very happy to recommend one to you. We don't have any direct official affiliations with any advisors or organizations. We don't get paid to refer to anybody. Just to make that very clear, we just want to ensure that our clients and others have the resources that they're looking for all the reasons that Shannon mentioned are important just a short while ago. So just to clarify that, very happy to provide any information that anybody's looking for. Yeah. Next question, it looks like might be okay, we've got a couple more. So if a trust is designated for a minor child for a retirement account, is there a 5-year time frame by the Secure Act, or once they reach 18 that the clock starts? So giving money to a 23-year-old would be still risky. Are there other options? The Secure Act is a payout in 10 years for most beneficiaries, but only 5 years for trusts. Any comments about that?
So in regard to the Secure Act, what I will say is yes. So if for retirement plan accounts, if you're going to list a beneficiary on that account, you want to take into account the Secure Act. So how it used to be is if you name your child on a retirement plan account as a beneficiary designation, they would have a lifetime to withdraw, but of course upon your death. But now it's changed. So yes, there is that 10-year period that they would need to withdraw from that account. But there are certain designated eligible beneficiaries who have a lifetime to withdraw, and specifically that is, a spouse. If somebody is named who has special needs, they would have a lifetime to withdraw. There's many different qualified beneficiaries who who do not need to withdraw that money within 10 years.
Okay. And it looks like the last question for now is, my husband and I had an estate plan created through a legal benefit I have through my employer. It was very transactional, and I'm not clear on what we have and may be missing. Would you be able to help us? That's something we hear frequently. Agreed, Shannon?
Yes, I absolutely agree with that. I've had people come in with documents from other firms, come in through just the exact situation you're discussing. I've had people come in who have created documents themselves online. And yes, we can absolutely help you. Come in, have an initial consultation. It's complimentary, and we can look through those documents and let you know if they actually meet your goals and if they hit on all of those different risks or things that may occur throughout, lifetime. So yes, absolutely bring your documents in, and we can absolutely look through them and let you know if it is in line with current Maryland law, in line with your goals. It talks about the different types of contingencies that may happen, and what happens during those certain types of circumstances and how you intend for them to be, because that's one of the big things I see in documents are, there is no safety net measures listed for if somebody is under a certain age, or if somebody may be receiving supplemental needs, and we want to make sure that all of those things are hit on, so that your estate plan flows how you want it to flow in the future.
Okay. And one question that I missed a short while ago, which I apologize for that, Michael, is the age of 18 defined as minor the same for all states? Do you know that answer, Shannon?
So what I say to that is, in Maryland it's 18, but I know in other states, and I can't remember exactly right now which state that is, but there are some other states where the age of majority is defined as 19. So no, that isn't true for every state. I think 18 is true for most states, but that is a great question. And the simple answer to that is no, it's not 18 for every state.
Okay. I think those are all we have for right now. Shannon, thanks for a great job today. As far as our webinar series going forward, everybody, I'll send out my typical follow-up message with some information from today, including our video links, so you can review this over and over and over again, as I know you will. And our webinar series will move forward on November 8th. We have guest presenters Karen Lawler and Donna Weaver from the Wendy Slaughter team of Elevate Realty. We'll be back for a third time over the past couple of years talking about aging in place and downsizing for your next chapter. And that'll be on November 8th at 10 o'clock. November 15th, we'll be having our quarterly trustee selection and how to choose the right one for you with Stephen Elville. On November 16th, our yearly VA aid and attendance, a tax-free pension for those that qualify. Also at 10 o'clock on the 16th with Lindsay Moss. And then on November 17th, that is a busy week for me. Estate planning and elder law essentials with Stephen Elville at 10 o'clock as well. So we're getting into, slowly getting into the holiday season here, one of my favorite times of year. And looking forward to sharing it with you with our webinar series. So we'll see if there's any final questions here, and then we will call this one a success. Let's see here. Looks like that's everything. Shannon, thanks for being here today, and to all of our attendees, thanks for your great questions, and thanks for being part of our Elville webinar series, and we'll see you again soon. Have a great day.
Thank you, everyone. Have a great day.